So, and our topic tonight is free software and copyrights.
But I have your attention.
Making North Court. All right. Well, welcome to free software and copyright. Recording good? Great. All right.
We're recording. The good thing comes later.
Yes? Streaming this? I don't know.
We're not.
We're not?
Nope.
All right. So
we're recording it for later publishing it on YouTube.
Someone else has it.
But we'll have it.
Yeah.
Live.
All right, so yeah, free software and copyright. Free software is a broad topic, copyright is a broad topic, and you know, the things have a whole lot in common. But today we're going to focus on just a few things. I've got the presentation split into 3 parts to help you keep time. Part 1, I'm just estimating about 25 minutes. You know, how does copyright work in the United States? It's probably similar in most other countries, but I mean, I only know the United States. Second part, we're going to take a look at free software specific issues. You know, how do licenses work? What license should I choose? And then finally, one recent court case related that has implications for the free and open source community, Oracle versus Google. It just got decided on by the Supreme Court, and so I'm going to unpack that ruling as just a case study in how copyright law pans out in practice. So first off, is anybody here a lawyer? Raise your hand if you're a lawyer. Okay, well you'll notice I did not raise my own hand. I am not a lawyer, and this presentation does not constitute legal advice. Now, what I do have is I spent about 2 semesters immersing myself in copyright issues because I'm a recent graduate of NC State University, and for my final project, I taught a 1-hour seminar course about modern copyright issues. So I think I know a lot. So I think I know a pretty good amount about copyright. However, I will say, 1, I don't have any practical experience with copyright lawsuits and litigation. Most of my perspective is going to be a bit more academic. So I will do my best to provide accurate information and practical information, but if you're in a position where this is could seriously impact your bottom line, like if you're Red Hat or someone, you should enlist the services of a qualified lawyer. So now that that disclaimer is on point, I don't know, questions. So I will accept questions during the talk. You can raise your hand at any time. I will call on you. There will also be a question break at the end of each part. However, we will be operating under strict time limits during the question break, so if your question is taking really long, I might have to defer it. If your question is something that I will address later, I might have to defer it. And if you start a licensing claim war, I am going to shut you down mercilessly. So, let's get started.
MIT.
That escalated quickly. Alright. So first off, where is copyright and where does it come from? The answer is copyright comes from Title 17 of the United States Code, which is the body of federal laws in the United States. And what it says about copyright. Copyright protection subsists, in accordance with this title, referring to Title 17, in original works of authorship, fixed in any tangible medium of expression from which they can be perceived, reproduced, or otherwise communicated. Which is kind of legalese, but not as bad as it sometimes gets. Basically, the point here, the key things. First off, copyright protects original works of authorship. I mean, someone might say, well then, does pop music get protected by copyright? Because it's not very original. And the answer is yes, it does have a modicum of originality, and that's what qualifies them for copyright protection. Copyright does not make value judgments about whether something is good or worthy of copyright protection. As long as it is a moderately original work of authorship, it is eligible for protection. Another important thing is, copyright does not apply until something is fixed in a tangible medium of expression. And that does include a computer's hard drive. The important thing is, as long as it's not ephemeral, you know? Like, if you just speak something out loud and no one's recording it, that's not copyrightable. If someone records you saying something, that is copyrightable. But The copyright does not apply to the medium of expression itself. It does apply to the work in the abstract sense. Question?
So, what if you just go scorched earth every night? Is that ephemeral?
What?
If you just go scorched earth and just like zero out your hard drive every night?
Okay, so if you create a copyrighted work and later destroy it, the copyright still technically exists, it's just that it doesn't matter once you destroy it. Yes?
What happens if it's generated by a computer algorithm based on random?
All right.
Is that an original work of authorship?
Good question.
I don't know. This is not the sort of, so the question was, is something generated by a computer an original work of authorship? The answer is, I don't know. It has never come up in court, and it is not covered in the law. So if it ever goes to court, we will find out. Like, one of the things is, the thing about the law, sometimes things are not defined. Not everything is defined in statute. Some things are only become defined when a court rules upon them, and that's one of those things that is a hole in the current copyright law that isn't explicitly addressed. And if it ever came to the courts, there would be arguments for it, there would be arguments against, and then the court would set a precedent.
Actually, it was a case like this year.
There was a case?
A monkey got a photographer's camera, took a picture.
The monkey selfie.
Did you see this?
Yeah, the monkey selfie. I was all over that.
It was ruled that the photographer could not hold the copyright, nor could the monkey.
Right. Right, yeah. Only humans can hold copyright, and if an animal was the alleged author, no human gets to claim their theoretical copyright.
If you look at how a lot of current movies are produced, I think they may qualify as computer-generated works.
No. If there's any sort of artist guiding the creative process, then the copyright falls on them. So in the movies it becomes a bit more complicated because of the corporate copyright, which we will discuss later.
You said the copyright applies to the work and not the medium that it's in, but
Correct.
haven't the courts ruled that a significantly different medium, it violates the copyright? You don't have a copyright in all medium?
I'm going to get to that. All right, that I believe would be a derivative work question. All right, anyway, no more questions on this slide. All right, another important thing to know about copyright, especially for software, in no case does copyright protection extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery. So, putting this in concrete terms, I invent a new sorting algorithm. I implement that sorting algorithm in Python. The code I wrote that implements that algorithm, that gets copyright protected. But the algorithm itself is not protected by copyright. Someone else can go and implement the same algorithm, and it will not be a question of copyright whether that is legal or not. So, again, ideas, systems, concepts, not protected by copyright.
What about the call gates to the APIs, not the algorithm themselves?
The what?
The function calls or the structure of the interface for software.
Oracle versus Google, we'll get to that. Yes. I'm staring at you, yes.
Would the process fall under the area of software patents?
Software patents. They exist, this talk is not about them. Reality, patents do exist, but I did not spend 10 months studying patents. I spent 10 months studying copyright. So let's move on. Alright, so what does copyright give you? This is laid out in section 106. Basically what it gives you is exclusive rights to do and to authorize any of these things, if you are the copyright owner. Reproduce it in copies, prepare derivative works, distribute copies, perform it publicly, or display it publicly. So, in general, there are exceptions which I'll cover in a slide, but in general, the copyright owner of the work is the only person who can do these things with that work. They're the only one who's presumed to be able to do that. And just to elaborate on derivative work, because I had a question about this in advance of the meeting. A derivative work is a work based on one or more pre-existing works, and in any form in which it may be recast, transformed, or adapted. It also means if you do editorial revisions, annotations, or elaborations upon a work, those also can constitute a derivative work, even if the original work does not necessarily appear in them. So, basically, if you use another work as the basis or as an element in a different work, your work is a derivative work, and that falls into the exclusive rights of the copyright owner. Like I said, there are exceptions. I'm going to get to those in a second. Yes?
Can you go back a slide?
Sure. Yeah.
It's helping it down. That's not allowed.
Yeah, so, perform publicly and display publicly, those also encompass, television broadcasting. The way copyright tends to work with new technologies is we create analogies to old technologies in order to allow the old laws to continue working. We can debate the merits of that approach, many people do, but that's the way it typically works. Yes?
How many people publicly?
How many people is publicly? Great question. Check section 101 to see if there's a precise definition. If not, you'll have to consult the case law.
Going back to the next slide. Okay, so you're saying that a book review or a movie review is classed as a derivative work, not an original work?
In the case of a review, it might not be a derivative work necessarily. If you include a quote, it would definitely be a derivative work, but we're about to get to a thing. So, there are limitations on copyright that are codified in several sections of Title 17. Personal use is interesting because it's not explicitly codified in law, but it is recognized by lawyers, judges, and copyright experts as a traditionally recognized right. So if it's just for your own personal use, you can make copies. So like I can photocopy a newspaper and hang it out in my cubicle, And the bounds of personal use are not generally defined in law, but one example is the Audio Home Recording Act, which says that if you do home taping of something that was performed over the radio, that's legal. Or making personal copies of tapes or CDs is legal. And that was a specific codification of the existing principle of personal use. Another thing which gets to your book review comment is fair use. Fair use says there are circumstances in which you can reuse a copyrighted work without the author's permission because it's fair. Usually this is for purposes like criticism, commentary, parody, teaching, research. So if someone publishes a book review, as long as they don't include the entire book in the book review, anything they quote from the book is likely to be considered fair use for purposes of commentary. Fair use does not have to be non-commercial, it does not have to be personal, but in general, something is more likely to be fair if it transforms the original work in some way, uses it for a different purpose than it was originally intended, or to a different end than it was originally intended. Fair use is fairly flexible. There's not an explicit list of things in the Copyright Act that says this is fair use, this is fair use, this is not fair use. But I tend to view that as a good thing. It means that we can be creative in how we choose to use copyrighted works fairly. Yes.
There is a four-factor test in case law, but also this could be its own whole hour-long talk. So.
Yeah, fair use determinations are complicated, but if you do things that other people have seen as have been ruled as fair use before, then you're probably safe.
But it's an affirmative defense.
It isn't.
So this is not a shield against getting sued.
Right.
So you could be dragged into court.
That's an important point. You can still get sued if you use a copyright work fairly, but you will probably win the lawsuit. However, if you don't have money for a lawyer, you might be screwed. There are also certain archival rights defined in Section 108. Some of them apply to libraries, some of them apply to any users. Then there's the first sale doctrine, Section 109. This is, once the copyright owner sells an initial copy of a book, for example, they lose the right to control further distribution of that particular copy. This is what allows used bookstores to exist. Used bookstores do not violate copyright because the copyright owner's right to control that copy of the book expired when they sold it. The way where sale applies to digital goods is a bit murkier, and I don't know, and that is one of the unfortunate things that is different depending on which circuit court you're under. But generally, you can't assume a first sale doctrine for digital goods. And then there are also some statutory licenses for cable and radio, but we're not going to worry about those. There's also another fundamental limitation on copyright, although unfortunately at this time it's mostly practical, copyright term. I mean mostly theoretical. So when something comes into existence, you have control over it for, I believe it's life plus 75 years? I don't know, some number like that. You have, copyright exists until you die, and then for a certain number of years after you're dead. And during that time, it's administered by your heirs, successors, publisher, whatever. Once the copyright on the work expires, it becomes public domain. All those exclusive rights are no longer exclusive. Anyone can exercise them. But in general, the only way things enter the public domain is through term expansion. And unfortunately, due to the influence of corporate lobbyists, Congress has been continuously expanding the copyright term for a while now. There's an old joke. All you need to know about copyright in the United States, Steamboat Willie, the first Mickey Mouse cartoon, will never enter the public domain. Yeah. And then there are some important things that copyright is not. Copyright is completely separate from academic integrity, which is like plagiarism. For example, I can plagiarize Shakespeare. I cannot infringe Shakespeare's copyright because his plays have been in the public domain for over 300 years. But I can plagiarize him. Similarly, you can infringe someone's copyright without plagiarizing them. If I were to, say, go to a bunch of photographers' websites, download photos, publish them in a book, and actually get where I got the photos from, but I didn't get the permission of the original photographer, that would still be copyright infringement. It is also completely separate from patents. Whether the ideas in a particular copyrighted work are covered by a patent is completely separate from whether the work itself is copyrighted. That gets to the idea-expression dichotomy. Copyright protects the expression of an idea, a patent would protect the idea itself. Copyright is also separate from trademark protection. So one practical example of this for us, Red Hat Linux, for example, is completely free software released under the GNU General Public License. However, it contains a large number of Red Hat trademarks. Trademarks are source identifiers. They identify where something came from or who endorses it. The whole idea behind Red Hat Enterprise Linux is it is certified as endorsed and stable and supported by Red Hat. If you build your own, it doesn't have that weight of the Red Hat trademark behind it, and so it's illegal to use Red Hat's trademark with it. So it's completely legal from the copyright perspective, but building and distributing your own Red Hat software would still be trademark infringement. And finally, copyright is separate from publicity rights. Copyright only refers to the author's right in a particular work. Let's say the subject of a photograph or the subject of a film does not have copyright interest in that work. They have publicity right interest in that work. And the case law for that is somewhat less defined. But one recent case involving this was Garcia versus Google. Everyone sues Google over copyright for some reason. Garcia was an actress who appeared in a film. She thought it was just a normal film. It turned out to be an anti-Muslim propaganda film. She wanted to have it pulled from YouTube because it was like really xenophobic. So she filed a DMCA takedown claiming that it infringed copyright. The court ended up ruling, as much as the film is scum and we really don't like the fact that your name is being circulated with it, you don't have a copyright interest in it, so you don't get to do that. Yes?
So if I create a work and I don't tell anybody about it and I don't go to the United States and register it, do I still have a copyright?
Oh, that's another important point. Copyright exists automatically. You don't have to register it. You don't have to tell anyone about it. As soon as it is fixed in a tangible medium of expression, an invisible copyright shield appears. So, and so is an evil power. Yes.
Who has the burden of proof if there's a discrepancy in court over who created it first?
So fun fact, you can actually copyright identical things separately. So if I write a haiku and then someone else writes the exact same haiku 50 miles away, we both will copyright over our individual renditions of that haiku. Even though they're exactly the same, we have unique copyrights on them. There is not a first to file rule as there is with patents. However, that is very rare that something like that would happen.
If I create a cereal box and violate somebody's copyright, and I send it back in time before the offer?
Okay, new rule. Ridiculous copyright hypos are for TriLUG. All right. Yeah, that's a brief crash course on copyright. Any more questions? We have, I believe, about 7 more minutes before I'm moving on to the next unit.
In the past, they talked about movies losing the copyright if somebody didn't renew them, like the Christmas movie.
Yeah, copyright renewal does not exist anymore. You get the full term automatically.
This is the question I was asking earlier. I recently started a new company and they had me develop a custom piece of software for them. But they didn't have me sign like an NDA or give away any of my IP when I joined the company. Where do I fall on that?
Work for hire doctrine. This, I forget which section of Title 17 it's defined in, but in general, if a work was made on your employer's time, using your employer's resources, it is the copyright belongs to your employer, not you. So, your follow-up to that was, I want to release it as open source. Well, you would have to get your employer to release it as open source, not you.
That answer, is that considered an assignment of rights, or does the copyright actually belong to the employer?
Yeah, it doesn't, it's not you assign it it's not an assignment or even an automatic assignment. If it's a work for hire, the copyright appears in the possession of the employer, not in the possession of you. And I use appears loosely. Yes?
So if I write a poem, while working at McDonald's, does McDonald's supposed to hold the copyright?
If you're on the block.
I think if McDonald's did not ask you to write the poem, then I don't think it would. If you write it on the back of a Happy Meal bag using McDonald's pen, then we start getting into legal gray areas. Let me know if this ever happens.
So I believe it's different if you're a contractor,
Right. If you're a contractor, then you are your own employer, and you own personally all the work that you create while you're contracted. You would have to negotiate that separately with your contractor. The person contracting you would have to include in the contract if they wanted you to assign them the copyright.
by default, it's yours.
Yeah.
So what if you're a student at NCSU and you're working on your senior design project, spending hundreds of hours
I'm familiar with the story.
on your own money to develop a piece of software? Who owns it then?
So, in the case of universities, Michael was asking about a specific situation. I'll save that for later. But university students, it is not presumed that the university owns copyright unless you are employed by the university and you make it as part of a job at the university. Stuff you make in class wouldn't count. However, NC State does have a policy that you do automatically grant the university a license to use it for whatever legitimate instructional needs it has. Yes?
And isn't it true, if you were to be in a position, the company would ask you to sign a waiver or document in the very beginning of hiring, that anything you create while working there is completely theirs?
I had to sign one of these when I started at a certain networking company. Employers can say as a condition of employment that you have to assign us, or at least license to us, anything you create related to our field while you're employed with us, even if it isn't necessarily using our resources. This is, and that has a complicated status in California. I don't believe the status is complicated in North Carolina. I believe that it's just blanket application there. You look like you have a question. Or you're trying to increase the volume.
Yeah, so, well, I was just going to ask if you had time or
had addressed that issues of copyright fall under both criminal and civil penalties?
Personally, I did not study too much about enforcement. Okay. So, first of all says, they fall under both criminal and civil penalties, which I'm assuming means that life can get doubly bad for you if you infringe it. Pretty much. Yes?
If I write software in one language while I'm employed for a company, and then I leave the company and I rewrite that in a different language, do I have the copyright on the new version?
If you use your original version as a reference, like if you translate it from the original version, it becomes a derivative work. If you just based it on the ideas that you remember from the original, then it's an original work. They would have to prosecute you on patent grounds or on non-disclosure grounds. All right. Any last questions before I move on to the free software section? Yes.
Isn't there a section, I don't remember the name of it, but it varies depending on law, but in the U.S. I believe it's, if you make a statue, someone photographs the statue, the person who made the statue still has copyright over your photograph, whereas if it's a building, they don't. I don't know what it's called, but it's a big thing on
Visual Arts Rights Act, maybe? I don't recall personally. Like, I couldn't tell you offhand. In general, I don't think you necessarily, I don't know. Okay, Richard,
How complex does a work have to be before it can be copyrighted?
Any modicum of originality counts, as long as it is recognizable as a work of authorship. And that's our last question. I am actually going by the clock here. Alright, so, hang on. So, now on to the free software part. So, how many of you have seen the 4 software freedoms? Alright, so the 4 freedoms were defined by Richard and Stallman as the basis of the free software movement, and these define what makes software count as free. The open source definition is very similar, but it's longer, and so I wanted something I could fit on a slide. Basically, software is free software if you have freedom 0, use it for any purpose. Freedom 1, see how it works and change it, which means having access to the source code. Freedom 2, share it with others at any cost you want. Free, pay, whatever. And then 3, share your changes with others to help them out, which also requires access to the source code. So the thing is, by nature, these exclusive Section 106 rights would infringe that, because you are the copyright owner of the software you write, and you would by default be the one who has exclusive rights. This is where licensing comes in. The important thing here is the phrase "to do" and "to authorize." The copyright statute is intentionally flexible about how you authorize these things, and so, for example, you can authorize it, and you can authorize the exercise of pretty much any of your exclusive rights just by attaching a little notice to the work in question. And this is where we get our traditional free software licenses. We're going to start with a very simple license, the MIT X11 license. Permission is hereby granted, free of charge, to any person obtaining a copy of this software to deal in the software without restriction, including without limitation the rights to use, copy, modify, merge, publish, distribute, and/or sell copies of the software, and to permit persons to whom the software is furnished to do so, subject to the following conditions. The above copyright notice shall be included in all copies or substantial portions of the software. So, please don't lose while you're at it. Yes?
Does that include the bit below it?
Yes. So, there's also a warranty statement which I did not include in space. Yes?
When you read that, I noticed you skipped the word sub-license.
Okay, sub-license is important, yeah. Alright, so basically what attaching this says is, I, as Matthew Fraser, the copyright owner, authorize anyone to exercise pretty much any of my exclusive rights in this software. And it also says permit persons to whom the software is furnished to do so. That means I'm cool with anybody letting anybody else do this as well. So basically what that abrogates pretty much all of your exclusive rights in the software. The only thing is you can put conditions on it. You can say, include my copyright notice and permission notice with any copies or substantial portions. Make sense? Yes?
Well, I mean, how do you, so did you just redefine what sub-license mean? Can I significantly, I mean, if I can't significantly alter the current
Right,
license.
that's a good point. So,
I mean, sub-license should mean that I can change what I allow.
right, that's another,
That I modify.
right, that's another good point. So, another thing is, when you modify or change something that is licensed under the MITx 11, you can sub-license. You can make it available under different terms than the original author said. So I can take MITx 11 code and release it in a GPL product, or release GPL derivations, or release proprietary derivations. But that doesn't change the fact that it was originally made available by the author under MITx 11. And, okay, everyone good? Everyone understand that? We're going to move on to another familiar license, the GNU General Public License, version 3. This is not the whole thing. I have subsetted out a relevant part of it. The whole thing is long, but it's actually, I don't know. Some people think, oh, the GPL is dumb because it's long. I think it's actually pretty brilliant. But anyway, what it says is, all rights granted under this license are irrevocable, provided the stated conditions are met. That's another important thing. You can't take away licenses in some, there's not, if you impose a license, you can take it away, unless you promise in the license that you won't, which is what that says. And so basically what it says, you can make, run, and copy, distribute, or publish covered works that you do not convey, which means basically give to someone else outside your organization, without conditions. So personal use, completely fine. Using it within your company, completely fine. But if you want to convey to someone outside your company, or the general public, or anything like that, it's permitted solely under the conditions stated below. And what those conditions come down to are, when you convey a verbatim copy, they get a license from the original licenser automatically. If you make a modification and you convey your modifications, you also have to use the GPL or another license that provides equivalent rights. If you convey it without the source code, then you must provide recipients with the source code upon request. These conditions are designed to enforce the four software freedoms. The reasoning here is, you benefited from the four software freedoms, your obligation is to make sure that others can benefit with them as you pass it on. And then one thing to note, you are not required to accept this license in order to receive or run a copy of the program. However, nothing other than the license gives you permission to propagate or modify any covered work. So, things that are personal use, things that are fair use, licenses can't stop you from doing. You know, if I include a sample of something source code in a book for teaching purposes, then, that would probably, that's probably fair use. The license can't stop you. The license can only stop you from infringing exclusive rights that don't get covered by fair use, personal use, or one of the other copyright exemptions.
So, is that a good time to define the word reciprocal?
Reciprocal.
This is...
Probably not. I'll get to that later. But, does that make sense? All right. So, now we're going to get into the issue of license compatibility. This is important. Listen up. So, when you incorporate code released under a particular license into a larger product, or you redistribute it, or you modify it, you don't have to release it under the exact same license. You only have to release it under a license that is compatible, meaning that the other license you use does not prevent you from exercising the conditions of the other license. We're going to use some really dumb examples here. Say that Michael releases some software under the Tuesday license. You can only modify it on Tuesday. Randy releases some software under the Retro license. You can't distribute it on the internet, only physical media. I can combine Tuesday code, Retro code, and public domain code into one grand product. It gets governed by the intersection of those licenses. which means I can only modify it on Tuesday and I can only distribute it on CDs and floppies. In the same way.
Mini discs.
Oh, right. So in the same way, if I take code that is under the Apache license of the GNU GPL, then when I combine them, I have to follow both licenses simultaneously with the covered work, unless it says you don't have to follow them in the original license. And so that's where the compatibility comes in. What this means is GNU LGPL code, Apache 2 code, MIT X11 code, you can all combine that together and it's all and it doesn't prevent you from exercising any of the conditions in the GNU GPL v3. However, because the GPL v3 is the most restrictive of those licenses, generally its conditions completely encompass all the conditions that other licenses impose. Does that make sense? Yes.
Or in another sense, another phrasing, it restricts any looseness in the other licenses.
Right, yeah. If one license says you can do a thing and another license says you can't do a thing, then you can't do it. Similarly, if another license says you must do a thing and another license says you can't do a thing, then it's just illegal to do anything using those licenses. And that's where we get the idea of incompatibility. These licenses are not compatible with the GNU GPL v3, meaning if you distribute them together, then that's illegal because you can't satisfy the conditions of both licenses simultaneously. You'll notice GNU GPL v2 is on the list. And that's because GPL v3 added some additional requirements and permissions to the license. But the Free Software Foundation is pretty smart. They came up with a solution to that. I'll explain it in a moment. Other licenses that are not compatible include the Eclipse public license and the CDDL. The CDDL is notable for being the license that ZFS was released under, and according to rumors, Sun specifically released it under the CDDL to screw over Linux by making it not compatible with Linux from the copyright perspective. And then obviously an all rights reserved license or a proprietary license is not going to be compatible with the GPL. And in practice, all licenses do have this notion of compatibility, but in practice the GPL is the one that you hear people talk about the most in terms of compatibility. Because generally the conditions it imposes are a superset of the conditions any other free software or open source license will impose.
Is this something that's been tested in court, or is this lawyers getting together and decomposing all the licenses and making their best guess?
Has it been tested in court? I can't think of any cases off the top of my head. It has gone to court. It is not... if it hasn't been tested in court, then I would be surprised if the courts ruled any other way. It's fairly straightforward law, contract law. Does that make sense? All right. Anything else on the subject of compatibility? All right. Well, fortunately, dual licensing is a thing. You are not limited to only licensing software once. I can take my code, I can release it under the GPL and the MIT X11 and the Tuesday license simultaneously. And when someone gets a copy of it, well, first off, if they receive a copy under one license, that's the license they're stuck with. So if someone only finds the GPL copy, they get it under the GPL. If someone only finds the MIT X11 copy, well, more accurately, I only give someone an MIT X11 copy, they use the MIT X11. And if you have multiple copies of a work under a given license, you follow the conditions of exactly one license. You don't get to mix and match. Yes?
So you're no doubt familiar with the term clean room. If I see a licensed copy of one software and I see a licensed copy of the other software and I create a derivative work, which one am I bound to?
Yeah,
Because clean room says, and this is why companies like IBM do this, you're not allowed to look at any software from any company without fully understanding the license agreement before you look at it.
Yeah, that's accidental derivative works could result. And so, some examples of this in the open source world. Firefox is under the GPL or the MPL, Mozilla Public License. And I forget why, it's something weird. MySQL is available under the Afro GPL, which I'll explain later, or you can buy a commercial license from Sun, or Oracle, whatever company it is now. And anybody who wants to use it under the AGPL can use it under the AGPL. Anyone who doesn't want to abide by the AGPL's conditions, they can buy a commercial license. This can make a very profitable business model for open source companies.
Now, one thing, I don't know whether you're going to talk about this or not, but it's different if you're dynamically linking to libraries that you include from other sources.
Yes, I'm going to get to that.
Okay, got it.
Yep. So, and then this brings us into GPL automatic upgrades. Like I mentioned, GPL versions are generally not compatible with the ones that came before them. So there's a solution. This program is free software. You can redistribute it under the terms of the new GPL as published by the FSF, either version 2 of the license, or at your option, any other version. That means that when the FSF publishes a new GPL version, your work becomes available under that too. So, for example, let me think of, what's in GPL? MediaWiki. MediaWiki was originally licensed under GPL2 or at your option any later version. When GPL3 came out, that meant you have the choice. You can either use it under GPL2 or GPL3. This means that this is what allows compatibility and prevents the free software ecosystem from destroying itself every time a new GPL version comes out. If you need to link it with GPL2 software, you do that under the GPL2. You need to link it with GPL3 software, and I should say combine. Link is a slightly legal term. If you need to combine with GPL3 software, you do it under the terms of the GPL3. Yes?
Was that clever little clause included in the original GPL2 license program?
It's not part of the license, it's part of the thing you attach to the license to indicate this is the license. But yes, the FSF has encouraged it starting from version 2. You also have the option to not do that. Linux kernel doesn't do it, BusyBox doesn't do it, Git doesn't do it. Those are stuck on GPL2 and they will be for all eternity. Unless they can get every copyright owner to agree to relicense it, which I'll get to in a second. This is kind of a weird thing. Is anyone unclear on this?
Mickey Mouse.
Yes.
And this is completely hypothetical, so if GPL version 4 came out and it granted all rights to everybody.
Yeah, all rights, everybody has all rights. Yeah. Yeah, if GPL 4 comes out and says anyone can use it for anything, I don't even care anymore, then yeah. All GPL software immediately becomes basically public domain. That's part of why not everybody uses the automatic upgrade clause. We'll explain the trade-offs of that in a bit. I don't know. Green shirt.
Who gets to decide that this is the GPL?
The Free Software Foundation, which is a Massachusetts nonprofit organization.
So if somebody else released another GPL version that wasn't them, they would say, no, that's not right.
Exactly. Yeah, and there's also a thing where you can say, hey, I'm not trusting the Free Software Foundation, but if Brian Gerard says he likes the GPL v4, then that means that I will accept the GPL v4. But if Brian Gerard sees GPL v4 and says, no, that's dumb, I'd be stuck on 2 and 3. Yeah.
That's the BGPL.
Okay. So, can I attach my own conditions to the upgrade?
Can you attach your own conditions? I think technically, but that would start getting complicated. That's the sort of thing you would want to ask a lawyer about.
For instance, when I die, it
gets stuck.
When I die, it moves to the upgradable version. While I'm alive, it's GPL2 forever.
You can write that, but you want to consult a lawyer to make sure you don't accidentally screw the wording up.
Okay.
And the body.
Alright, one thing to notice, you can only license material if you are the copyright owner or you are authorized by the copyright owner. And so, for example, the GPL2 would not, It gives you, so like the MITx 11 license would give you the authority to relicense something under whatever. The GPL2 only gives you authority to relicense under the GPL2. So, and another important thing, if someone so like, say I go on GitHub, I release some software under GPL2 only. I make some commits, some people come along, they do a pull request, submit some code, I merge that back in. And then it keeps going. What happens is, there's a sort of copyright chimera. Everyone's individual contributions are still have the copyright owned by them. Whoa, that was bad. So as a result, so if it was MITx 11, I could relicense it, no problem. But since it's GPLv2, if I wanted to license it to GPLv3, for example, I would have to chase down each contributor and get them to relicense their stuff to GPL3. Unless I had that later version clause in there.
That brought up an excellent point where companies are stuck using previous versions of the software that have bugs in them because of the software license that they were licensed under.
Yeah, you want to be careful about that. But that said, project leaders do have options. First, one is copyright assignment, which is, I take my copyright, I transfer it to you. So like, I give up my copyright and Michael Marley becomes the copyright owner, for example. There is one modification right I have, which is in 50 years if I don't like the way he's using my copyright, I can take it back. But other than that, he becomes the effective copyright owner. The other thing is contributor license agreements, which is basically a super licensing agreement that you sign just between you and the project leader that says the project leader can license it under whatever they want, or under any open source license or whatever. Any questions? Yeah.
On the topic of chasing down previous contributors, does it matter at all how minor the contribution is? Like, what if a guy added a semicolon where there wasn't one before and it made it compile?
Then I think you could maybe argue fair use, or something like that. Technically, I think it would still be a problem, but I mean, in practice, I don't think you would get sued over it, and I think it would be considered de minimis, which is a legal term meaning very, very tiny, and thus not actionable as infringement.
Do open source projects take steps to prevent people from checking in spurious copyright notices into the...
The smart ones do. And this is why knowing about copyright is important, because if someone puts some illegally obtained code in your repository and you distribute it, you can be liable for infringement. Anyway, and the reason for that is 17 U.S.C. Section 103. The copyright in a derivative work extends only to the material contributed by the author of that work. So when I make a derivative of something, only my new contributions are my copyright. Everything that was original still retains the copyright from the original author. Now on to the fun part. What license should I use in 5 easy, strike that out steps?
I thought you said we weren't going to have license words.
No, see, okay. I'm going to avoid a license word here by giving you a very important choice. But first, you have to stay with me through this. First, 5 things to never ever do. 1, don't create your own license. Have you ever heard the term don't roll your own crypto? What? Basically what it means is don't write your own cryptography code, because cryptography code, there are a lot of things that can mess up without and a beginner wouldn't even realize that they messed it up, but they can make it completely worthless. Law is the same way. There are a lot of things that you do, that you could think are completely sane from your perspective, but because of the way a term means in the law, or because of an edge case you didn't think about, it turns out making your license completely worthless. So, you writing your own license is like writing your own cryptography. No, it actually works. It's like a lawyer writing their own cryptography software. Because you're working in a foreign language that you're completely unused to. Next thing, don't post code and not license it if you want it to be open source. If there's no license attached to a work, the presumed default is nobody can do anything with it. All rights reserved, except for getting some personal use and all that. So if you post code and you actually want it to be considered open source, slap a license on it. Don't use Creative Commons licenses for code. Creative Commons is great, but their licenses are not designed for source code. They are designed for other forms of creative works. And also they're GPL incompatible. So if you Creative Commons license some code, it won't be able to mix in GPL software, and that causes bad things. Here's one of the licenses I'm about to explain instead. Don't just say public domain, because in many jurisdictions you aren't allowed to put a work in the public domain. It only enters upon copyright term expiration. Instead, the Creative Commons people, and this is the exception to the one before it, Creative Commons 0 is a very broad license you can put on a work that says, this is in the public domain. If that's not possible, here are all the rights that I'm willing to waive. That basically exhausts all your copyright. So it effectively puts it in the public domain, even though it's not technically public domain. And Creative Commons 0 is the best way to do that, if you want to do that. And don't use obscure licenses unless you really have to, because figuring out license compatibility is really hard even with just 6 licenses. When you start throwing random licenses in there, it becomes even harder. So use one of the common, well-understood licenses. For example, don't use this, the WTF-PM. Don't do it, because A, it's obscure, B, it's never been tested in court, so nobody really actually knows what that last sentence means in the legal sense.
What is this from?
It's in OSI's list of valid licenses.
The Free Software Foundation approves that it is technically free software as well. It is still a bad idea to use.
That's version 2.
And I will say, because like, I can guarantee, because I mean,
The first one didn't have sensors.
yeah, so don't, well, I mean, I changed the name. You know, I changed it to the DUIB F*** if we want to, public license. Yes?
So I want to say it's Fedora, but I know one project still accepts the WTFPL as one of their acceptable licenses.
Oh yeah, I mean, some people will take WTFPL code, but like, if IBM, for example, came across some WTFPL code, they wouldn't touch it, you know? Because, I mean, that is just not a legally rigorously defined term, you know? That's no risk Moving on, what license should you use? Now that I told you what you should not use. Here's something helpful questions. First off, do the licenses of your dependencies or source materials require a specific license? If you create a derivative work of GPL, you gotta go with GPL. That's just the law. If you create a work that incorporates GPL code, you also have to go with GPL. It's just the law. And other copyright licenses work the same way. The next thing to think about, does your language or framework community have a preferred license? For example, in Lua, which was one of the programming languages I used a lot starting out, Lua itself was released under the MITx11 license, so there was a strong trend to release Lua libraries under MITx11 as well. Whereas over in the Python community, BSD is more traditional. So you want to think about following your language framework community's traditions in order to make the lives of your compatriots and their lawyers easier. Then think about, do you need an automatic patent license clause? Some licenses include a clause saying, if by releasing this software, you grant anyone who receives the software a license to any patents necessary to operate it. This is so that, for example, say there's a patented MP3 codec, for example. If the company that invented MP3 releases software that is free software that for decoding MP3s, but they said you need a patent license to use it, and that costs $50, it wouldn't really be free software. So instead, licenses with automatic patent clauses require anyone who gives away code also to give away whatever patents are necessary to licenses to use whatever patents are necessary to use that code. Now, there are not always reasons to do that, like it's not always necessary to do that, but if you're doing something that involves maybe a codex or anything else that is likely to come under patent protection, you should get a license that has an automatic patent grant clause. I'll explain which ones those are in a minute. Yep?
Can your license force someone else to give up their patent? If you use the software, you give up your patent.
No. Then it becomes not free software. All right, and then final consideration. Would you prefer a copyleft or a permissive license? This is the most important question, and it's not one that you can necessarily answer objectively. It's going to be about your personal values and your goals for the software. So, permissive licenses are similar to the MIT one we discussed. It's basically just do whatever, you know? And why would you want to do that? Well, one thing is, you want to encourage people to use it as widely as possible. It could be because you want to make, like, you're a programmer, you're frustrated all the time with how terrible computers are, you just want to help, you just want to make people's lives better, your fellow programmers, and you don't want to put any barriers in their way that the legal departments might get mad at. That would be a good reason to use a permissive license. You might want to promote a standard or a codec or a file format that the software implements, and so you want people to use it as much as possible. Or because you just want to gain a reputation and feel cool. Yeah, so another reason to be permissive is to allow for future commercialization of the software without the other contributors needing to clear you. So if I release an MIT X11 open source project and get a bunch of other contributors, then they would have to, I can release commercial derivative of that later with no problems. If I did that same thing with a GPL, I would have to get all the contributors to license it to me or assign their copyrights to me in order to do that, because I could only license the parts that I wrote under a commercial license. Why would you go with a copyleft license? Copyleft means that means derivative works and modifications must be under the same license or a similar license. Why would you want to do that? One is, you care about free software. You want to ensure users always have the four freedoms, either because of ethical grounds, or because you just believe, or because of something like cryptography, where you believe it's essential that users have to trust the source in order to trust the software. You might also want to ensure that companies can't commercialize without giving their modified code back to the community. Or you might want to ensure that companies can't develop features that would outcompete the community or your company. So there are a variety of reasons. This is a decision you have to make for yourself. Once you've made that decision, I can help you pick which license. That is a bit more objective. So that displayed badly. So the little smiley faces are happy faces, and the boxes are faces. So
your little smiley faces look like those blue energized Pac-Man.
Yeah. So MIT and BSD, those two are pretty much identical. They are very short and compatible with everything. The downside is they don't have an automatic patent license grant clause, and there are multiple versions with confusing names. If you want to use one of these, make sure you're getting the right version, and make sure you're getting a version that is actually free software. GNU.org has some resources you can use to figure that out. The Apache license V2, it includes a patent defense clause. The downside, it is not compatible with the GNU GPL v2. If you need to combine it with Linux or Drupal or BusyBox or another project that is GPL v2 only, it won't work because the GPL v2 does not include a patent defense clause. That's the downside of patent defense clauses. So does that make sense? Yeah.
It's compatible with GPL v3?
It is compatible with GPL v3. So if you only need to combine it with software that is 2 or any later version, or 3 or any later version, or 3 only, it's fine. Yes?
Don't you have to be specific in a 2 or later that it isn't 2? Don't you have to make the choice that...
Yeah, you would have to make the choice to only use it under 3. But yeah, it will combine. In practice, the final distributor is the one who gets to decide between disjunctive licenses, because they're the ones who have to process everything. Yeah.
So something rolled up from 2 to 3, or 3 to 4, somewhere along the line, would the user get to choose which one that they got? But, or would the automatic update clause say it has to be the newest one?
No. The automatic update clause never takes away an old GPL version. It only adds new ones. So you can never lose the right to use a GPL program under your current license because of an automatic upgrade.
Okay.
Alright, and then thinking about copyright licenses. In practice, the only copyright licenses you will ever want to use are published by the Free Software Foundation. The GPL is the GNU General Public License. It has a condition. All the words must be GPL. LGPL says, lesser general public license. You can use it as a library in a proprietary program, but modifications of the library itself must be LGPL. There's some additional legal subtlety on that. You can go to GNU.org for the details. I'm not going to go into that full detail here. The AGPL is the Afro-General Public License, which is GPL plus, if you run it on a server, you must provide users with the source code. So like say uncloud, if it was released under the GPL, I could modify an uncloud, put it up on a web server, and charge people to use it, and then wouldn't get the source code. If uncloud is AGPL, which I believe it is, then any modifications I make to my uncloud and let other people use, I have to give them the source code for. Here's a handy flow chart. Can someone else do this thing with this software? Well, with software under this license. None of them will let you modify the software itself and redistribute it to people under a non-free license. The LGPL will let you use it as a library and distribute it to people under a non-free license. The GPL and the LGPL will let people run a copy on the server and not give users access to the source. And none of them will protect you if the GPL work is a completely separate component that is just used by a larger proprietary software system, because at that point, there's no copyright link between the GPL thing and the rest of the system. Yes?
Are you going to talk about that linking, like what it means to combine and what independent means?
No, because that gets into some technical details that vary between languages. Generally, I would recommend if you need advice on that, GNU.org. They have very comprehensive FAQs about licenses. Yes?
Right. So if I wanted someone to be able to use it as a library, but I wanted the source code to be available, is there one that specifically is tailored to that?
As in,
I see there that there's not one where you can use it as a library, but you also must give the source code if it's used on a server.
I'm not sure that would make a lot of sense, personally, but no, there is not one that does that. Yeah.
What does the library mean? In the old days, library...
Go to GNU.org. But basically, if your program, especially given some of the recent rulings in Oracle versus Google, basically you can assume that if you refer to the library in your code, then you've created a link for licensing purposes. I'll get to Oracle versus Google later and explain where I believe that reasoning came from, and I'm not going to take any more questions on this topic.
Well, you should take one more question on this topic, because it's a good one. In the advent of containers and microservices... That's true.
Microservices, that's a good point.
Microservices, the licensing of libraries is going to change significantly because of object code only of releases of containers.
Yeah, that's going to be interesting. Yeah, because,
Question.
Well, it was the same.
I want his comment on it.
I would love to comment, except that we're running low on time. Right, moving on. So then there's some stuff you have to think about for GPL and LGPL versions. First one is, should you use V3 only, or should you use V2 as well? The good news with V3, it has a patent defense clause and an anti-DRM clause. The anti-DRM clause is really brilliant. What it says is, if you use GPL3 software to make DRM software, it doesn't actually count as DRM under the Digital Millennium Copyright Act, so it's completely legal to use it to break DRM. This is an example of pretty sweet legal engineering. Unfortunately, some software is V2 only, V3 is not compatible with V2. So, and if you license it as 2 or 3, then companies can use it to make DRM and say, no, you're using it under the V2, and then your users get screwed. Then there's the question of, should you allow automatic upgrades, which is the or later clause. Good news is, no compatibility problem with future GPLs, and nobody will ever lose the ability to use this software. If you use the or later. The downside is GPL reform might grant permissions you don't want to, and you can upgrade manually in the future if you're careful. Personally, one thing to note, this is a big table showing which GPL versions are compatible with the other. I mean, it does get complicated. You can find this table on GNU.org. The important thing to notice, the only no's appear when people say only and don't have the or later clause. So something to chew on. So, easy flowchart. Are you cool with automatic GPL upgrades? And my opinion is you probably should be. And do you either want patent defense and anti-DRM clauses? Then we pick this.
Can I say GPL3 as long as you have the anti-DRM clause in the preceding version, the succeeding versions?
Because you don't have the clause 3 does.
If you want to start getting really funky with the automatic upgrades, I email the Free Software Foundation and ask for their opinions.
Okay.
So, licensing questions? Warning, strict time limit. 4 minutes. Go.
So, what has been tested in court with software licensing?
Well, it does work.
It was a court and won appropriately?
Yeah, and it has won, and specifically the derivative work and provisions of the GPL have been tested in court. So if you make a derivative, or if you link a GPL software in and redistribute it, then yes, you do have to abide by the GPL. That part is definitely enforceable. Some specific things that haven't been tested. The precise definition of link has not been tested, which again, you can read about it because I'm not going to talk about it more. And the new anti-DRM clause has not been tested yet. Some other things have not been tested, but in general, I'm confident that most of the GPL and stuff would hold up in court if it got to court. Yes? Brian?
2 quick questions. One of them, let's say I have a GitHub repo full of software, can I just put a license file in there and have it cover the entire thing? Do I need to include it in each file, or
including it in the header of every file is better, but if people only obtain it by cloning your Git repo, then, the license will probably still apply, but it's safest if you put a header in each file.
Sure. Okay. The other one was, as far as you manually upgrading a license, that's just replacing the license verbiage and then creating a new release or whatever.
Exactly. Yeah, to upgrade a license, you just make a new release that includes the new license text. You do need to make sure that you stand by any copyright owners in the source code to do that, but if you do, that's all it takes. Good.
If a copyright owner knows of infringement and then condones the infringement, how long do they have before they can't sue over that infringement?
I don't know that. I'm not as up on the enforcement law. GNU.org. Yes.
So if I want to release a new piece of software that I write myself under an open license and then let people contribute to patches and use it, and then later on slap a commercial license on it, did I hear rightly that it should be an MIT license?
If you want to do that, yes, use an MIT license. You greedy person.
So I was wondering, what if you have an open source repository, and I think we were talking about this before, somebody commits code that is under an incorrect license for that project, and that could have some legal ramifications. So what are the legal ramifications of somebody taking the license from a piece of code that they've that they want to incorporate into that repository or whatever, and stripping out a license and putting in something completely different, something that doesn't reflect where they got the code from?
That's illegal, and you can be sued over it, and I don't know what the penalties are, but it's probably bad. All right, time's up. Moving on to Oracle versus Google. How many of you have heard of this case? Yeah, it was in proceedings when I was teaching my copyright class. I tried to keep a pretty close eye on it, but I mean, but most of my class was aimed at non-programmers, so I didn't have too much of a reason to focus on it. Here's what happened. Google, in order to make Android work, Google created an independent star implementation of the Java SE APIs to use on Android. I say independent star because one of the things at issue was they may have copied some code illegally, but that is not relevant to the facts of the case at large. For the rest of this, I'll assume that the implementation was indeed independent.
Any of the authors, who are the authors of the original Java?
Yes, the work for hire doctrine. All right. Oracle sued Google for infringing the copyright of the API's structure. Google did have options. They could have either used it under the GPL. They didn't want to. They wanted to release it under Apache. I mean, they could have used Sun's OpenJDK under the GPL instead of writing their own under Apache. Or they could have written their own implementation and submitted it to Sun's TCK, Technology Compatibility Kit, testing, in order to verify that it was compliant. They didn't want to do that either because they didn't want to be beholden to Oracle because they were kind of competing with them. And so then Oracle sued them, and here's what Google's argument was. APIs are not copyrightable because they comprise a method of operation. The precedent in that case was Lotus versus Borland. What happened was Borland created a spreadsheet software, and it reused all the menu structure from Lotus 1, 2, 3. Lotus sued, and what the circuit court ended up ruling was that because the menus just counted as a method of operation, and so not an actual copyrightable expression, and so it was not copyright infringement. And so Google was banking on that precedent. I believe that was Fifth Circuit. Yes?
That was the very famous look and feel case from, 35 years ago?
I don't know.
More than that.
I forgot the number. Point is, I mean, they're both dead now and everyone uses Excel. And another argument was because of interoperability concerns, APIs should not be copyrightable under the idea-expression dichotomy. Because, basically, their argument was based on the merger doctrine and the scenes up there doctrine. Those are not specifically codified in law, but they have been developed through judicial precedent. Merger doctrine is, if there's only one way to express an idea, then the idea and the expression merge. And so, if you express your idea in the same way, then it's not copyright infringement, because that was the only way you could have expressed the same idea. Similarly, the scenes up there doctrine says if something is not copyright infringement if it's so common, everyone would expect you to use it. You know, the conventions of I'm not sure that really counts, but conventions involved in a particular literary genre, or maybe the hero's journey. Something like that, maybe even. Well, that's just an idea. You couldn't copyright that. But if there were, say Prince had been successful in getting everyone to use that stupid symbol for his name, right? And then he started suing people for infringing the copyright on his name symbol. That would be scenes up there because, I mean, that's expected when you're talking about Prince, to use that symbol. But we didn't have that option because everyone just said the artist formerly known as Prince instead. All right, and then Oracle's arguments. First off, APIs are a form of creative expression, and so they fall under Section 1 or 2 basic definition. Original work of authorship, fixed and intangible medium of expression. And Google could have written their own if they wanted to, and they could have licensed Sun's APIs if they wanted to. There was nothing forcing them to write their own compatible implementation of the API and thus infringe the copyright. They also also said that Google's argument was bad because interoperability concerns would not affect copyrightability, they would only affect infringement testing, which is the merger doctrine and the seems unfair doctrine. And basically what they were saying is the merger doctrine and seems unfair doctrine don't affect copyrightability, they affect if you infringe the copyright, is that actually illegal? Because, fair use does count as infringing copyright. It's just illegal because it's fair. And their precedent was Sega versus Accolade. This was a situation where Sega wrote some code for activating the DRM system on the Sega Genesis. Accolade copied that code, and the court ruled against Accolade because they could have found another way to trigger They could have found a way to trigger the DRM system that didn't involve copying Sega's code. And now Accolade's dead. So that was Oracle's arguments. And what ended up happening in trial? In 2012, the district court found for Google, and that their API is not copyrightable. In 2014, the Court of Appeals found for Oracle that their API is copyrightable, but said this could still be fair use. Interoperability would be a valid defense for fair use. We're going to send this back to the district court, and they're going to decide whether it was fair or not. Or Google appealed again, and then the Supreme Court decided that they would rather rule on Berger versus ACLU and some other cases than this, and so they passed up the opportunity to set a national precedent.
Well, sending it back to the lower courts to decide.
Exactly. So, as a result, APIs are copyrightable, but only in the Ninth Circuit. But you will note that the Ninth Circuit contains literally 90% of tech companies in the United States. But fair use still applies, and depending on what the circuit court rules in the upcoming case, we could say, and it could get defined, interoperability is an important concern for fair use, where even though an API is copyrightable, creating an interoperable creating an interoperable thing is important enough that we will assume it's fair for the future.
Either that or everybody can invent their own steering wheel.
That too. That's another option. Not a preferable option. And honestly, I'll be completely honest here. From the legal perspective, I personally find Oracle's arguments pretty compelling, but I do think that there should be a strong presumption of fair use for interoperability concerns. And if the circuit court ends up not ruling on that, then we could have problems. Yes?
So did Google just copy the names and identifiers, or did they copy okay, so it's just the actual way that end user would call the method?
Well, and then the strong typing involved in the plugin.
Yeah, and they did copy the exact expression as well, the way it was written in the source code files, like the way the method declaration was written. But that was where the merger doctrine came in. They said, even though we copied that expression, it's the only way to express the same idea. So it's not copyrightable.
But the actual implementation?
The implementation, they wrote their own.
Okay.
And then, was there something else I wanted to say? Bill?
And they should have copied the OpenJDK API.
Well, they didn't want to subject their code to the Apache 2.
Right, but that's likely to get sued by them and by Oracle.
Oracle wants OpenJDK, actually.
So does anybody know whether or not IBM saw the handwriting on the wall where this was going, and that's what killed Harmony? What made Harmony was another Java implementation. It was an open source Java implementation that started before.
I think a better question might be, because this has evolved for a long time, things like Microsoft J#, which was definitely killed by an earlier court case.
Yeah, but that was because they modified it.
Yes, but.
Yeah, I mean, that was a violation of the,
It was a derivative work.
No, between Sun and Microsoft. That went to court and Sun won that court case. I'm talking about yet another alternative implementation of Java that was quite a big deal, and a lot of folks were engaged in it, but it was obviously being supported strongly by IBM. And I wondered if anybody knows whether or not there was an overlap.
I thought that's just because people didn't want to spend money if OpenGDK was there.
No, actually, well, they specifically wanted to get out from under Sun, is why they launched that. They wanted an alternative implementation of the class libraries that was not entangled with Sun's commercial interests.
I don't know how they license it, but IBM still has their own.
We should probably take this one to try.
Yeah, we should take this one to try, so I do just, stop talking.
We should probably take this.
No, I'll take a couple more questions.
Why is Boiling not operative?
Why is Boiling not operative? It was said in the Fifth Circuit. This case was decided in the Ninth, so it's not technically binding precedent. The Ninth Circuit could have borrowed it from the Fifth Circuit if they wanted, but Oracle was saying there's not a guarantee that they would borrow it. Circuit courts are weird like that.
So given this, is C# licensing better than the Sun original licensing for Java? Does it give us more freedoms?
I don't know. All right, and then just before we sign off, one interesting thing to chew on. So APIs are copyrightable, right? Well, you mentioned before there was a lot of things I was avoiding saying about linking. That's a term that's defined pretty core in the GPL, right? And the idea the thing is, when you write a program in C, you can get oversimplify a bit. Basically, when you compile it, even if you dynamically link the library at load time, a bit of the copyrighted elements from the original library stick into the executable you kept around, you're sending, you're giving, right? So basically, the stuff defined in header files. And so that was the argument that the GPL used to say this creates a combined or derivative work, because when you distribute it, it sticks a little of the metadata from the object code in your executable along with it. What's interesting to think about this decision, if APIs are copyrightable, even in a link, that means that, so like in Python, by contrast, like I write an import statement, that is not, like that doesn't put any of the library itself into my code. You know, it remains separate. I obviously have to know what the names and signatures are in order to use it, but it doesn't copy any of the person's original code in there. But if APIs are copyrightable, then using a GPL Python module and importing it and referring to its names would drag a little bit of that API metadata in there, at least in the abstract logical sense. And so that's why I think that if Oracle versus Google stands as precedent, then the GPL's linking terminology might end up referring to non-completely dynamic languages as well.
Why would the merger clause not cover that?
Because you can write and run.
Now, well, in order to link with the library, I mean, there's only one way to express the signature, right? I mean, how can the signature be confused?
Well, you don't.
Yeah, it's an equivalent call date is what he's saying.
Okay. Yeah, it's not an airtight argument. You know, we can talk about it. I mean, at TriLUG or whatever. But I mean, that's just something I was wondering about when I was ruminating over the potential consequences of Oracle versus Google in my head.
You want to talk about the loose tech license, which is a little different?
The what tech license?
The license for tech source code.
No, because we only have 7 minutes until bandwidth kicks us out. All right, thanks for coming, everyone. One just last important notice. All right, you go to my website, www.leafstorm.org, the text version of this talk is posted up on there, basically. So if you want the license referencing thing. So, I'm not taking any more questions, sorry. We will have TriLUG after this. Let me get those, directions. Let me get the directions back up here for y'all. And, yeah, thanks for coming, and thanks for listening. And
Hey, one of the questions for those who haven't signed the member form, where are they?
The box.
They're back in that corner.
Okay, thanks.
I'm talking about the steering wheel. You have to read the GPO first, though. You have to read the GPO first, though.
Oh, also, fun fact, I got through all but like this much of my city hall.